Hello and welcome to UNESCO. Today we're talking about the vital role that judges play in protecting freedom of expression and journalists. Created in 2013, UNESCO's Judges Initiative is a global program which builds judges and prosecutors' knowledge and skills in defending journalists' rights and protecting our right to freedom of expression. I'd like to introduce two experts who represent organisations working very closely with UNESCO on this initiative. The initiative is 10 years old, as I've said. This is the Judges Initiative, and it really is a pioneering programme. Today I'm joined by Kate O'Regan, who's the director of the Bonavero Institute of Human Rights at the Faculty of Law at Oxford University. And Kate was also a judge on the South African Constitutional Court. I'm also joined by Han Moraal, the Secretary General of the International Association of Prosecutors. Welcome both of you, and thank you very much for joining me. Shockingly, today, 9 out of 10 journalist murders are never successfully prosecuted. So that's a global impunity rate of 86%. And UNESCO's Observatory of Killed Journalists records 1,400 killings of journalists between 2006 and 2023. Nearly 100 journalists are still killed every year. So there's a lot more work to do because journalist murders are solved far less frequently than those of non-journalists. So UNESCO's program works through mass online trainings and workshops, and we've trained 36,000 judges. We've also worked with Columbia University to create a database of case law. And now there are 2,700 cases on that portal, which judges and prosecutors can use to help guide their judgments. So first of all, I'd like to ask both my guests, both Kate and Han, to help define freedom of expression, because it's not the simple concept that we think it is, the right to free speech. It's not only that, is it? If I could start with you, Kate.
Well, of course, that is what it is in the first place. It's the right of all of us to express our opinions, to talk about things we care about, and not to be subjected to prosecution or to other consequences for doing that. Most of the difficulties arise actually about when it's acceptable to limit the right, not so much about what the content of the right is in the first place, because whether it's expression that is verbal, whether it's in print, whether it's online, all these modes of expression are protected by the right. But international human rights law recognizes that the right is not absolute. In the founding document of international human rights law, which is called the International Covenant on Civil and Political Rights, the document says that states must take steps to prohibit speech that is going to incite harm or that is going to be fundamentally demeaning of people on the grounds of their race or their gender or their religious beliefs. And so these are limitations on freedom of speech, and it's often the intersection between the right and the limitations where the difficulties arise.
I see, thank you. So it's quite complex for prosecutors and judges in the courtroom. They need to really understand that delicate balance.
Correct.
And Han, if I can ask you, I understand that freedom of access to information is also a fundamental part of freedom of expression. So how does that work? Why do we need to be able to access information to help us express ourselves freely?
Well, information for all creates a level playing field for fair discussions in society. And that's important for, let's say, the general level of fairness in a society. So for prosecutors, it's not a matter of their own opinion how far freedom of expression can go, because that's for the law, the rule of law in a country to limit or not. But given that limitation, which I personally think should be very limited, but given that limitation, it's the task for prosecutors to see that everybody gets his turns in saying what one wants to say.
Thank you. That does make sense, that we need access to the facts in order to be able to debate freely and fairly. Okay, thank you for that. So, Han, if you could give us some examples of how the Judges Initiative, UNESCO's Judges Initiative, has had an impact over the last 10 years in promoting freedom of expression, that would be great.
For the International Association of Prosecutors, it's only 3 years, because the prosecutors were involved in this project more or less 3 years ago, when we took together with UNESCO the initiative of spreading, let's say, this important project and make it into the curriculum of prosecutors all over the world. For that reason, we organized in-person trainings, massive online trainings. We had a training during one of our conferences, and in that way we trying to train prosecutors to have attention for the freedom of expression in a way that it is the task of journalists to bring that information to the general public. And any violence on journalists will prevent that and will harm society. So that was a reason for us to step into this project.
I see, okay. And do you, does your organisation have evidence that the judges have been able to put this training into practice?
Well, I'm at least sure that prosecutors do, because you have to understand that in many countries the prosecutors are the filter between the police and the judges. And if a prosecutor comes to a judge with a well-prepared case, 80% of the work is done, and judges will most probably also give it let's say, a good view. If prosecutors don't do their work well, which is not only the matter in cases of violence against journalists, but in general, then you also have lousy verdicts of judges. So prosecutors, they play a significant role in fairness and justice in society, also when it relates to violence against journalists.
I see, okay, thank you. Thank you for highlighting that link there between the police and, the prosecutors. That does seem to be very impactful. And Kate, as an experienced judge, can you explain what role judges can play in protecting freedom of expression and describe some of the challenges that they also face when they're doing this?
So, of course, what's important for judges is when they hear a case to think about whether freedom of expression is implicated, and to recognize the importance of freedom of expression, protecting freedom of expression. As I say, the difficulty often arises around this area of limitations, because of course what tends to happen is that it will be argued that a particular limitation is a justifiable limitation. And it is for courts to be careful and consider whether indeed that case for the justifiable limitation has been made out. This arises in a lot of cases. So wherever, for example, you might have a prohibition on a gathering or a march. Now, of course, on one hand, that is a case about the right of peaceful assembly, but it's also in some ways a case about freedom of expression. And then the question is whether those who are wanting to prevent the march or impose very onerous restrictions on it have made out a case that it's appropriate to limit in those cases. And judges need to be very alert to the idea that it's very harmful to limit freedom of speech, and not only to be listening to arguments about other harms that there may be. They need to give a proper weight to freedom of speech in considering those cases.
I see, so they're like a sort of backstop, and they can control the impact of politics on freedom of speech.
Well, they certainly, if the cases come before them, they will often have political implications where they're politically sensitive. But for the judges, that's relatively irrelevant. What is relevant is whether the balance is properly struck between the need to protect freedom of speech, and here I'm with Han, that freedom of speech is a very, very important value, and we should generally allow very few restrictions on it. And to make sure that judges recognize that, and that they don't allow restrictions to be take place which will limit freedom of speech inappropriately.
I see, yes. So earlier today we heard an anecdote from one of my colleagues here at UNESCO about a judge who had a personal opinion on a case, but because he'd participated in this initiative, he actually had to keep his personal opinions in check. I think that must be quite a common thing when judges have been trained in international standards, that they become more objective in the courtroom. So that's an obvious positive outcome. So just to move on, Kate, I wanted to ask you about the climate that we're living in today. I understand that the Bonavero Institute has concerns that due to democratic backsliding that we're seeing around the world, that some gains in freedom of expression are actually being eroded, and laws are being weaponized by governments in order to do that. How do you and your colleagues measure this democratic backsliding on freedom of expression?
Well, there are several major projects around the world that measure democratic backsliding, and one of the measures that is relevant to that is the extent to which there's an increase in censorship, there's an increase to limitations on speech. So that's a very important social science investigation, which is not the kind of thing we do, but we certainly monitor those very closely. And one sees that limitations on freedom of expression are part of what some people call the authoritarian playbook, or the ways in which backsliding occurs. And there are several others. So, for example, there can be attacks on free and fair elections, or the limitation of the right of people to vote, or there can be direct attacks on the judiciary, forcing judges to retire, or in other ways undermining the independence of the judiciary. There can be attacks on civil society, saying that civil society, for example, may not receive funding from particular quarters, or may have to register in order to engage in civil society activities. So there are a range of behaviors which are part of democratic backsliding. But attacks on journalists, attacks on media outlets, another quite common one actually is the use of the market to purchase media outlets and then limit the array of views that are represented in the media. So the media becomes very consolidated with views that are sympathetic to an authoritarian government, and counter views are not permitted. So there are patterns of these we see in countries all over the world. Yeah. And I think one of the first things is for us to be aware of that as citizens, as citizens of the world, to realize that these risks are there, because if we don't pay attention, we can suddenly find that actually we're not hearing things that the government doesn't want us to hear. And that, of course, is very harmful for exactly the reasons Han gave. We all need to have access to information. We need to hear different views in order to be able to make up our own minds.
Thank you. No, that's really interesting. And it makes me think about the digital sphere, which is also being weaponized to limit our freedom of expression in some ways, because disinformation is flooding social media platforms, obscuring the facts, obscuring the true stories. So that's obviously weakening our right to freedom of expression in the way that you described earlier, because it's reducing our access to factual information. So I understand that in the last year, there's new data from an organization called Access Now that shows that internet shutdowns are being used by governments. So there's not only disinformation being used, there's also this, shutting down of the internet. Could you explain a little bit more about why it's on the rise around the world, these internet shutdowns, and what can prosecutors and judges do to fight back?
Two things, because when you're talking about information or disinformation, that's a very difficult one for prosecutors, as it is not for prosecutors to decide what is true and what is not true. That should be the professionalism of journalists, and I think that prosecutors should keep away from that. If in the nowadays where digital information is, let's say, 95% of the information shared is blocked by an internet shutdown, then in fact you are limiting very much the information sharing, and that is indeed something that people should stand up against. That might not be a criminal case, so it might not be that prosecutors are involved that much in those circumstances, but for me personally, it's a fact of a proper functioning democracy that there is access to that digital information. But that's a personal opinion, but that's lesser for prosecutors to take care of.
I see, okay, thank you. Or maybe I can ask you, Kate, what's a judge's role in pushing back against the use of internet shutdowns?
Well, it will vary from country to country, but what one needs to realize firstly is that an internet shutdown threatens freedom of expression, access to information, but very often a whole range of other rights, access to education, access to healthcare. We now use the internet pretty well all our lives.
Everywhere.
Most of us feel, oh my heavens.
We can't function without
Yes,
it.
we can't function without the internet. So when one is generally thinking about limiting rights, so for example, freedom of speech, one of the things one thinks about is how important the purpose for that limitation is. I think when you realize how important the internet is to all of us for so many of our rights, then a complete internet shutdown is going to be very, very rarely, if ever, justified, because it may be justified against one right, but say, for example, a system where people get access to education or healthcare through the internet, or their ordinary employment, or a whole range of things. So a general blanket internet shutdown is enormously invasive of people's rights. And this is something we're only beginning to realize now. It's sort of fundamental character of the internet is something we're only beginning to understand. I remember about 15 years ago when I was told that Finland was thinking of introducing a fundamental right to the internet. I remember thinking, that's very bizarre. But now it seems like absolutely essential that you recognize that all of us have a right to online communication and online access. And it's a vehicle for many to protect many of our other rights.
And a judge could technically push back against a government that was abusing that
Well, it
weapon?
will vary from jurisdiction to jurisdiction. So, for example, there's been a recent decision of the Court of the Economic Communities of West African States saying that internet shutdown is impermissible. But it will depend a little bit on each country and how rights are protected. But for example, if you live in a jurisdiction where there is a Bill of Rights, a fundamental Bill of Rights, which protects your right of freedom of expression, access to information, and there is a blanket shutdown by the government, then I think that you would be able to rely on your rights and go to court and say this is an unjustified infringement of my right. Of course, it's a little bit more complicated than that, because what often happens is these are private service providers who close down actually the pipeline.
So you can't tell who's behind it.
So there are often quite a lot of complicated facts involved.
Yeah.
But the principle is that at times this will come before courts, and courts do need to recognize the fundamental rights that are protected by access to the internet and ensure that that's not taken away from people unless there are profoundly important reasons for doing so.
Thank you. Well, that's encouraging. So I wanted to ask you, Han, given that freedom of expression is really, we talked about it before, so threatened in the online sphere, how can judges prepare themselves for these new challenges that are thrown up by technology? I understand that the Judges Initiative is trying to evolve the curricula all the time so that it takes into account developments on social media and AI. How can the individual judge keep up, or prosecutor?
No, that's no problem. But of course, there might be a difference. And now you're bringing up the general theme of specialism with prosecutors and judges. And what you see throughout the world is our experiences is that prosecutors easily are let's say, specializing themselves in all kinds of types of crime, digital or whatever, while judges don't. They often want to be general judges and take care of all the type of cases, which makes them vulnerable, not knowing all the details. What I'm saying now is pretty general, but there is a difference in prosecutors, more focusing on specialism than judges in my view. So what I can say to judges, please specialize. See that you know about how it works. That can be about cybercrime, that can be about corruption, it doesn't matter, but also about dealing with digital ways of communication. In general, I dare say that there are more specialist prosecutors on this topic than judges.
Thank you. Okay, then that's an important distinction. But it's obviously, there's a big onus on judges to read all night, never to sleep in a way, because they have to be specialists in everything. And it goes back to something that Kate said in the panel earlier today, that we assume that just because they have so much training, judges are across all of these issues and they know what the rules are, the international rules, the national rules are on every topic. And that's what makes this training so important, because clearly they can't be specialized in every single human right, can they? So they need a specialized body like UNESCO and also your organizations to support them in this. How do both of your organizations, if I could ask you first, Kate, and how do you envisage the future with this initiative? Like, it's clear that with an impunity rate of 86%, there is a lot more work to be done. So what new areas do you hope to go into on this initiative?
Well, I think the digital world in particular is developing very fast. I mean, we've all just suddenly become aware of generative AI, ChatGPT, and all its lookalikes. And that is going to create enormous challenges for thinking about how the law operates in this area. Just a simple example, if somebody decides to use ChatGPT to generate a series of social media tweets, and suddenly ChatGPT generates a highly abusive tweet of somebody, who's liable for that? And so, you know, there are a whole range of questions that are going to be emerging. And as the technology continues to develop, the law is going to have to catch up. And I remember hearing that the founder of Google once said that social media companies move 10 times faster than ordinary businesses, and the law moves 10 times slower than ordinary businesses. And that generally generates a gap. And I think that's one of the reasons why this initiative has been so important.
Thank you. And Han, how do you envisage your organization developing this initiative?
Well, it's for the academic world, it's for UNESCO, it's for the International Association of Prosecutors, International Association of Judges, to keep up with developments and keep informing prosecutors and judges. It's like the main theme in the film Lion, never give up.
Thank you. Thank you both so much for joining me today.
My pleasure, thank you.